But this is a panel about gaming of patent litigation. And I want to try and start doing more stuff to get to the root of these problems. Because I think there are bad actors on both sides of the V. There are good actors on both sides of the V. And I think all too often, many of you probably heard me say this, I think that we treat each other like, or the industry treats us like we're in third grade. Somebody does something wrong, and then the whole class loses recess, you know? And so what I really want to try, and we're going to do this here, and we're going to do this at live as well, and increasingly, try and put some real fact and meat on the bones to talk about what really is going on that is both good, bad, and ugly, so it's not just we're talking about ships passing in the night, really. So I'll introduce briefly Jamie, and I'll ask you to also, fill in the gaps and introduce yourself further. But Jamie Simpson is the executive director of C4 IP, and it is, I got that right? That's
Chief Policy Officer.
Chief Policy Officer. Okay, and she is. She's also spent time on the Hill. She spent time at the Patent Office, so she's very knowledgeable about all the bills and all the problems and what people are trying to solve and accomplish with what's going on. And C4 IP is a relatively new, I guess you would call it a think tank, right? Is that yeah? Think tank in DC, and it's kind of spearheaded by Andre Iancu, David Kapos, Judge Michelle, and Judge O'Malley are probably the four primary movers. And right, your executive director is Frank Cullen.
That's right.
So it's a really powerhouse IP think tank in DC. So I've asked Jamie to moderate this panel, so I'll just kick it right over to you, and thank you for being here.
Yeah, thank you for having me, and it's great to be here, and I've really enjoyed all the panels. And as I was preparing for this one, I also realized, although I started as a patent litigator, kind of seeing all this stuff for myself, I've been out of that for a while and in the bubble that is the policy world. So I'm really curious to hear what our panelists who are in the trenches have to say, and would love your input as we talk on these issues, which I find interesting. I deal with them every day, but they're really about setting the rules that everyone has to live by. And to what Jean said, one of the reasons I joined C4IP about, I guess, a year ago now, is that they really wanted to promote doing empirical research to try and get at some of these questions. And we're just getting a lot of this underway, but I think that really goes to this is that, I think there are some right answers out there. It's one system that needs to fit a lot of business models, a lot of interests, and that's really hard to do, but I think it's kind of an internal discipline that hopefully can make the patent system and our innovation economy really strong. So with all of that out of the way, I will let our panelists introduce themselves. I'll start with Katie.
Great. Hey everybody, I'm Katie. I think I already met a lot of you, but I'm very excited to be here. It's been really fun meeting all you guys and talking to you. So a little bit of background. I actually started as an environmental engineer working for oil and gas companies. So for all of you scientists, physicists now getting into patent law, I was there at one point too, and nothing that I'm saying now made any sense to me back then, but it does now, most of it. And from there, I actually ended up becoming a patent examiner at the PTO, and I worked in the business methods art unit right when the Alice case dropped. And so I was on the kind of forefront of 101 issues, and that really got me interested in law and what was going on, and it got me really interested in patent policy. But as I've been talking to Jamie over the past couple of days, I realized I'm not following these issues very well, and she knows a lot more about them than I do. But after being a patent examiner, I went to law school while at the PTO, and I ended up becoming a patent litigator at Kirkland, and I was doing that for about 4 years. I focused on like really hardcore patent litigation and trade secret litigation, and from there I moved in-house about 2 years ago, and so now I'm in-house at Renesas Electronics, which is a large Japanese semiconductor manufacturer, and we have all sorts of issues related to IP, antitrust, just like global relations about the semiconductor industry, and it's been really fascinating. And I get to deal with patent trolls, IP ownership issues. I kind of deal with both sides of these issues. And so I've both litigated for patent owners, I've defended against patent infringement claims, and now as a company, I'm kind of seeing both sides of this as well.
Hi, everybody. I'm Bette Muirhead. I'm an attorney and IP litigator at Merchant & Gould in Minneapolis. In my former life, I was a biologist and environmental chemist and went to law school after working for a medical device company and getting interested in regulatory affairs. I do all the I do all the IP litigation that anybody wants to send me, along with all of the ancillary contract and warranty related type stuff. So I'm excited to talk about what's going on.
All right. Well, let's jump right into it then. The first thing, just kind of wanted to address the issue head on, this term patent troll. I think one person's patent troll is often another person's champion, but at the same time, I think we can't really be naive about the fact that there are abuses of the patent system that go on both sides of the V. So with that as kind of the premise, I'd like to ask our panelists, what are some of the main abuses you're seeing? Are they coming from the patent owner side, the accused infringer side, or both?
You want me to start?
Sure.
Okay, so there's two main kind of abuses that I see a lot of. The first is, I think, kind of what you think of as like a traditional patent troll. And the way that that plays out at a company like mine is you get a letter or an email, or my favorite is someone just mailed me a book of 900 patents and said, consider this service, you're infringing at least one of these, give me a call. And so I was like, okay, that's fine. So we get accused of infringing a lot of patents all the time, and you have to kind of take it with a grain of salt. Like, we have to look at each one. Now, the 900-page book we didn't really do a lot with, to be honest. I was like, that's fine, just like serve me something. But we have to like look at those, and you have to take into account a lot of considerations, because if you have a decent claim, it's okay. If I pay you a license agreement, right, how many people are going to come after you asking for these license agreements? And so we're going to talk a lot about, efficient infringement and things like that later, but it's a big consideration of if, okay, it looks like you maybe have a valid patent. Do I pay you a license agreement? Do I go litigate this? We have to look at that every time, and it's coming in. We're getting these claims all the time, right? Like once a month, I'm getting someone coming and saying you're infringing our patent, and we have to go look at it. We have a whole tech team in Japan dedicated to this. And whether or not it's a troll or, a valid patent owner is not always apparent on the face of it. A lot of times, other than the 900-page book, that's a troll. In case you want a definition of a troll, I think there you go. So that's, I think the first abuse we're seeing is kind of the very traditional. I think most in-house lawyers have seen some form of this, is a letter, you're infringing our patent, let's start talking. Do you want a license agreement? Do you want to be paid off? Do you want to go, litigate this? Those types of issues. The second form of issues, which I don't think get a lot of attention, and this might just be specific to my industry, but it's something that's been going on for a number of years, and for other in-house folks, you may or may not relate to this, is kind of abuses in underlying IP contracts. And we see this particularly in relation to IP license audit provisions. And so what happens is when you're a company like mine, you acquire IP, the way that you pay for it in one of two ways. You either pay an IP license fee or you pay a royalty. And you usually don't do both. But in these provisions, they'll say, okay, if you're not paying a royalty, then you need to keep track of who does and report it to us so we can go make sure the royalties are right. And then they'll audit you for underreporting. And if you underreport, you end up owing these huge penalties. So for example, you might pay $5,000 to $10,000 for an IP license, and they'll come after you and say you owe us $10 million in audit royalties when you don't have a royalty obligation to begin with. And so this happens a lot on like manufacturers and people in this industry, and it's all of these contracts tend to come with arbitration provisions, and so it's all kept out of like any type of spotlight. But it's something we deal with a lot, like multiple times a year, is we were dealing with these IP audit provisions. So I will caution you, if you're in-house, please take a very careful look at your audit provisions in your licenses, because we're seeing like just a really rampant abuse of them, and it's been increasing in the past few years.
And I'm just going to add, from kind of going back to the first point and the random letters and the sort of classic troll behavior, some of the trends that we're seeing a lot recently is what I kind of call the double dipping. So you'll get a letter from somebody asking for, what seems like maybe a fairly reasonable settlement amount to just make the things go away. So you get sent one patent with a claim chart saying, here's how you're infringing our patent, pay us, I don't know, $5,000, that kind of thing. You might do a little negotiating, but it's a reasonable amount. You just want to make it go away. You're done. And then the next thing you know, you get a letter from the same attorney. Maybe it's a different patent owner, or maybe it's the same patent owner, same attorney, different attorney, with, well, here's another 4 patents that you're infringing. And so we're seeing that a lot more with these kind of nuisance value cases. Seem to be somewhat test cases to see, are you willing to pay, and can we ramp it up? After you pay us once, can we ramp it up? Next time it's $10,000, and then after that it's $15,000, to see sort of, when will you hit your limit? Can we do the boiling frog approach to bringing our cases?
Yeah, just a quick follow-up on that, because this is definitely an issue that I heard on Capitol Hill a lot. But when you're getting those, and if you are kind of inclined to settle them, do you take any, kind of steps in trying to draft the settlement to preclude that? I mean, I know you can't necessarily if they're different patent owners, but just what is your thought process there? What do you try and do knowing that this dynamic might be going on?
It's an interesting question, because obviously you can't, for ethical reasons, you can't ask an attorney to, make any warranties in a settlement agreement, although I've seen settlement agreements that are drafted with kind of warranties and representations about what the party knows about other patents and releases. So you can try for a release where you get a release for any and all claims the patent owner, and I think you should. I think this should be standard, and you'll find out very quickly if you're dealing with a patent owner that has a large portfolio that they're going to try and come after you repeatedly with. But get a release that says, we're releasing you from any claims that we could have brought at this point on this or any other patents in our portfolio. You'll find out fairly quickly if they're acting in good faith with that one. But one of the things that we're also seeing are the affiliates, or I don't even really know how to describe it, but the not related companies necessarily, but different entities using the same attorney, and therefore having kind of information about what's been brought, what this party settled for, that kind of thing, whether they're acting under the umbrella of a funder, a non-practicing entity, or if they're just using the same law firm. And I'm sure for all the litigators out there, maybe there are some names that pop to mind when I say things like this, but it makes it hard because you can't have a settlement agreement where you say, and your attorney represents and warrants that there are no other claims that he's aware of or she's aware of that could be brought against you, even though you'd kind of like to. But they can't ethically do that, and I don't recommend, if you're on the other side, signing any such agreement on behalf of a client where you do make such a representation and warranty. But that is one of the things that we are seeing is not even just double dippers in the patent owner space, but the double dipping. It's sort of like the old ambulance chaser concept with personal injury, but with patents kind of thing. You get one guy who, or girl, I don't want to be specific,
Mostly guys.
who builds up a repertoire of patent owner clients, and then comes back over and over and over again. So
We definitely see this a lot, and I think we've kind of taken we've taken kind of one approach to this as a company to avoid these issues is like the nuisance suits we typically will not pay, right? Like you're infringing this patent, we want $5,000-$10,000. And we actually had a company who did this, and we said, no, we're not going to pay. So they tried suing us. They realized that they didn't have any standing. Case got dismissed. They tried suing us in a different state. Case got dismissed. And then they tried suing us again in a third state. And at that point, we actually filed a motion for frivolous lawsuit and sought attorney's fees, just to say, like, basically a hard stance of we're not going to put up with these nuisance suits, and if you come after us, we're going to go after you for frivolous lawsuits and for fees. And it was to make a point of don't come after us with this stuff. And contrary to that, when we do get these letters and the infringement looks valid, and we're entering into discussions, and we do good faith discussions of we have a tech team diving deep into this, and if we think there's something there and we're going to get into licensing discussions, we're going to get in licensing discussions for your entire portfolio, not for this one patent, right? Like if you want $10,000 for this one patent and we think there's something there, we're going to enter into talks for your entire portfolio and look at a bigger number, because that gets rid of this problem of you coming back again and again and again. So anyway, that's how we've kind of addressed those two issues, and it seems to, so far, be working okay.
On a further practice note there, I think make sure if you're a patent owner you have standing before you file suit.
That's also good, yeah.
Yes, thanks. So kind of looking at the flip side of this maybe a little bit, in contrast to the patent troll narrative, now that I would say on Capitol Hill we're seeing more attention on the big tech companies, especially in areas like antitrust, one of the things we're seeing, but more in the patent realm, is more attention to the fact that these bigger companies are accused of wearing smaller opponents down in court, smaller patent owners, for example. And one of the narratives you hear a lot is that a big company gets into a licensing agreement with a smaller startup who has an interesting new technology, and maybe they're going to talk about either an acquisition or a partnership or a joint venture, and then suddenly the license negotiation evaporates. The small startup doesn't hear from them anymore, and then 6 months later sees what they consider their product just on the market from their big rival. And while they might have a patent, it's going to be extremely expensive to go against this big rival. And so, that's kind of a challenge in this environment. So considering this kind of flip side of the patent troll narrative, I kind of want to ask the same questions. Have you seen any of this in your practice? And is there anything besides the sheer cost of litigation that you think is driving what might be the power imbalance in these dynamics?
So prior to in-house, I litigated a case with those exact facts, like to a T. It was, two guys, solo inventors, small company of 6 people, got into a development discussion with a big tech company, got deep into discussions, had the whiteboard out showing the tech company how it worked, and the tech company guys ran out of the meeting, never called them back, and then the product was on the market like 6 months later. And it took, and we'll probably get into, there's litigation funding concerns, all those things that happen. It took these guys over 10 years to get the funds and the backing necessary to take on this tech giant, right? Like they raised they raised millions of dollars just between themselves, friends, family, and then they had to go get litigation funders on top of it. Like it took a decade to prepare to go after a tech giant. And we fought long and hard, and it was brutal, and the case is, I believe, still pending, even though I've been gone from this law firm for 2 years. But it's hard. It's a real hard fought battle, and it's really hard to show things like, independent invention versus what the big company engineers were saying was done in-house, right? And now that I'm in-house, right, I'm on the flip side of this. Like, we're looking at small companies, and we're looking at IP deals or possible acquisitions. And I can tell you from the big company side, is the big advantage that they have is me, right? They have an in-house lawyer sitting there holding their hand, telling them, these are the contracts you need in place before you have these discussions. These are how these discussions will go. I'm sitting there saying, what type of information are you going to talk to them about? Let's talk about confidential information versus trade secret information. This is how you're going to have this conversation going. I can guarantee you that the guys I was defending did not have any benefit of that. They were going in, bright-eyed and bushy-tailed, thinking that they were going to get a payday and a big partnership, and they were willing to talk about everything. They weren't worried about, NDAs and the like. They thought they were covered with a standard thing, standard form you can get. So in-house lawyer, huge. The negotiating power between the parties, right? Like if I'm a big company talking to a smaller guy, I'm saying, why am I going to invest in you? Why are we going to look at acquisition if you're not going to tell me how this works, right? Like, you're giving me a black box. Why should I invest in you? I don't know if it's going to work. So they have to tell me more, right, than I have to tell them. So it's negotiating power, lawyers, time, money. Like, there's just so many factors working against these small inventors when they're getting into these situations.
Yeah, I agree with everything on that. Interestingly, my experiences with that sort of David and Goliath thing have actually been mostly outside the patent space, but I think some of the lessons apply. Similarly, one of the things that I tell my smaller clients when I am counseling them on IP stuff, and we're talking about I'm having a meeting with like maybe one of my big dream customers, and they've sent me their form contract and their form with their form NDA and all of that. We'll go through it and we'll look at it and we'll talk about, what does this mean? Can you live with that? Because I've seen it. I had a client who I love dearly, whose company was destroyed by a large company taking what she had created and winning because the facts just weren't good. And, it's still a little broken heart there. And so that's one of the conversations that I'll have with a smaller client when they're talking about having talks. And if it is something where they say, no, I can't live with it if they take it, then the next question is, okay, well, can you live with it if you don't get this contract? And if the answer to that is yes, I just redline the contract and we send it back. And if the big company goes with it, because because we're never trying to make it unfair, I just try and make sure that they're actually protected. And sometimes you're going to run into a legal department that's just like, yeah, no, you don't redline our contract. That's just not how that works. And I understand that. But when you do have these small clients, then maybe it's their whole life and maybe it's their dreams and all of that. I just think it's important to really make it clear to them, yes, you may not get this contract. But on the flip side, if you sign this contract, that non-disclosure agreement isn't as great, and sometimes it's also as soon as you share it with us, it belongs to us. And I'm just kind of like, okay, all right, guys, seriously, this is what we're doing. Yeah. And so having kind of that balance. The other thing that I've seen recently, and this is in the patent space, and something that I think the big companies should be thinking about before they decide to engage in what we'll call efficient infringement, and something that I think younger startups and younger people who are more savvy with social media should really be thinking about is the power of getting the story out there. I very recently on LinkedIn saw a woman telling her story about her invention and her patent, and naming and shaming the big company that took what was hers. And she has a patent. And she said, I don't have money to enforce this patent. And so they're just going to take it. But she had 1 million views on her LinkedIn post. And we've seen in the trademark space, we've seen companies, like I can't remember the exact details, but backcountry.com went after a small little website that was selling something that like arguably probably infringed a backcountry trademark, but they were a really popular small supplier in the space, outdoor enthusiasts. And so they went out and were like, hey, outdoor enthusiasts, these guys suck. And everybody agreed. And backcountry.com had to back down and be like, yeah, never mind. No, we don't mean it. We're really sorry. I think their CEO might have resigned. Like, it was bad. Social media has power. And so I think that'll add an interesting dynamic to some of this as we go forward, and especially as innovators who also understand the power of just getting your story out there. So if you have clients that are those big companies who are thinking about maybe ripping off a small company, obviously everybody in this room is going to be advising them to not do that, because that's just not nice. But also maybe just put out on the table that like it could also be really bad for you if the story gets out.
Can I jump in real quick? Because one of the things that I've always talked to inventors about is if they, with their story, if they get their story out early, then that is always helpful. What I've seen over the years, far more often than not, is an inventor or a small company, startup, great story, great technology, great technologists. They get, in my opinion, screwed like we're talking about right here, but their lawyer won't let them talk to me on the record, or anybody that could potentially do what you just said. And then what happens is then they lose, and then their next call's to me after their lawyer has dumped them. And I'm like, well, now you went from being a really great story to now you're a bitter loser. Mm-hmm. And that's just unfortunately the way that everybody's going to look at it is, oh, well, the court said your invention wasn't really all that great. You went after Google for no reason. You went after Apple for no reason. You're the bad guy. And so that is something that all the lawyers in the room, the private firm lawyers, need to really think, 'cause I couldn't agree with Bet more. I mean, you have some real power right up until you have zero power.
And I think when we were talking in the pre-session, you were saying your small clients, or maybe it wasn't that, or it was something similar, got tagged with the sort of NPE label because they were small and they hadn't been able to commercialize yet. And so technically they were non-practicing entity. And so they got tagged with the NPE label, which, we all know is kind of synonymous with troll. So
it goes back to, how Jamie started this. How do you define a troll, right? Because I had 2 guys who invented something really great, but they never got to commercialize it because a tech giant ripped them off. So the tech giant went after him and called him a troll. And it's like, these guys are not trolls. They're not at all. They made this, they worked hard. And then that also ties into litigation funding, right? Like another really hot topic is the fact that these guys had litigation funding. Should that be known? Because that plays directly into the troll theme, right? Our tech giant, what they wanted to go say to the jury was, this is not some homegrown invention. This is, a guy who put this patent to come after us, and he's got the backing of, this investment firm with millions of dollars. That's the narrative they want. Whereas our narrative is much different. This is a guy who came up with this invention. It was stolen from him. And in order to even bring this suit to you, he had to go get funding. And so I have a lot of opinions about litigation funding because this was a very hard-fought battle about whether or not the litigation funding details would be revealed in this case. And we obviously argued they should not, because it does nothing but bias the jury against the story, the narrative we're trying to sell. Now, do I think courts should be aware of litigation funders? Yes. I think that they should have to. I think the court should be aware of the funding setup that's going on, because there is a lot of abuse there, right? Like there's shell companies behind shell companies that are funding things, and it's a big network of different things going on, and it does influence, the court's decision and the parties' interactions. But I don't think any of that, needs to be made available to a jury. I don't think a jury ever needs to know if a litigation funder is involved to understand if a patent is infringing. And B, I don't think that the other side is ever entitled to litigation documents. And that's because of litigation documents litigation funding documents tend to be kind of the playbook, right, for that entire case. Because when you get litigation funding, you are analyzing a case from top to bottom about if this happens at this point, this is what we'd settle for. If this happens at this point, this is what we're settling for. I mean, it's the golden keys for the other party. They have no reason to negotiate with you. They know every weakness you've ever identified. Like, it is so hard to fight against that if they get that information. Not to mention it's like highly attorney-client privileged.
What is the argument in favor of relevancy for this presenting this information to the jury?
I can talk about my case, and I'm sure you have many other things to add here. The main argument that was used was it was highly relevant to the evaluation of the patents, right? Which goes back to our damages experts in patent monetization yesterday, is it's really hard to put a number on patent worth. And the other side saying this is like the most concrete evidence of what they think their patent is worth. Right? So if they have numbers saying like, this is what I'd settle for here, here, and here based off these weaknesses, that is like the best evidence you can ever bring to show what that's worth. And they also say like, you don't have to give us the attorney-client privilege stuff, just like tell us who's giving you all the money and how much you'd pay. So that's usually what they say. We obviously don't want to do that.
So I don't actually disagree with you on pretty much anything that you said there. I also don't think that litigation funding numbers should really be relevant to whether a patent is infringed. I do understand the argument, and depending on which side of the V I'm on, I can understand making the argument about the valuation point. Although I don't think it's actually all that accurate as far as an actual valuation of the patent, because funders are doing the like, what's your possible ROI and all of that kind of stuff. I will say, I think that there's information that's less than that, and it takes us back to kind of the troll and the shell companies and all of that, that is super useful. I don't know that it ever needs to get in front of a jury, but I think it's something that courts should be requiring more. So Delaware, I can't remember if it's Delaware generally or if it's like a couple judges on the Delaware district, have started to require really fulsome disclosures of affiliated parties, real parties in interest, including litigation funding, the identity of litigation funders, to the point where I think Judge Connolly recently referred a couple attorneys for ethics violations for failing to comply with his standing order on that. Because, and this goes back to if you don't know who might be coming after you when you engage in these settlement talks, finding out who's that underlying funder and being able to go and look, well, what other patents do they own? What other portfolios do they own? What other companies are they funding? That kind of thing can give you a little bit of the insight before you enter into a settlement negotiation with a company. And so I'm actually, we're watching what's going on in the Delaware courts and seeing, because it's the Delaware's where, after TC Heartland, Delaware's where it's going to be happening. So the fact that the judges seem to be taking really seriously and doing what they can to kind of bring forth some of this troll information, I think is going to be a really good thing. But I do agree, generally, depending on which side I'm on, that all of the details and using things like litigation funding to try and bias a jury. I mean, I think that's what a motion in limine, and I think judges should consider those. I don't know that that's. I agree with you.
Thank you.
Really, that's all I'm going to say.
Yeah, I would just add there, if you're interested, there was actually a whole hearing on this in the House over the summer. So there are a number of lawmakers who are interested in this issue and have suggested they would like to see legislation that might do what one of the judges in Delaware, I believe is just Judge Connolly, but maybe
Okay.
another one has
Yeah.
adopted it, does in terms of requiring automatic disclosure in every case. And some lawmakers have also written to the Judicial Conference to ask them to consider looking at making national rules on this. So, if it's something that might, impact you or your clients, you should follow it. It's definitely something that is on people's radar. And just the reasons I've heard, they do kind of go back to the transparency issue, the idea that there are funders who are maybe funding lots of different portfolios, and this idea that if you settle with one, there might be another one, and if you're the person being accused of infringement, you don't want to settle with one only to have to deal with another one right after that. With the flip side obviously being, if you're a small entity, a small patent owner, it's just not practical in many cases to go to court unless you have funding. And depending on what sort of disclosure is required, that's kind of giving away the keys to the castle. And I mean, there are a lot of gradations of this too. It's, do you disclose to the other party? Do you disclose only to the judge? So, it's not automatic that it has to go to the other party. So there are different ways of dealing with this, depending on what you want to do as, these rules progress. But it's definitely an area of interest. So anyway, turning to another piece of legislation that was just recently introduced, this is the Restore Patents Act. And it is a bill it's actually a very short bill because what it does is a single and pretty straightforward thing, which is to reverse the 2006 eBay versus Merck Exchange decision. And that was the decision that reversed the longstanding presumption in district courts that if you're a patent owner who's proven your case, so you've proven infringement and you've prevailed in showing that your patent is valid, then you are presumed to get an injunction, and that gives effect to the exclusive rights to your invention that has its roots in the Constitution. So anyway, eBay versus Merck Exchange changed all that in favor of a 4-factor test that, if you look at the numbers, has definitely decreased the number of injunctions that you see being issued. This bill would change it so that the presumption basically exists again. So I have a number of questions, but given that we have 4 minutes, 3 minutes and 30 seconds, I'd just be curious to hear your thoughts on this.
So I have a lot of thoughts on this because I work for a semiconductor manufacturer. So injunctions, not like the best thing for our technology, right? Like if you think about, like take an iPhone, right? Like there's probably 1,000 patents on an iPhone, 1,000 different pieces of technology. Like let's say I have a chip in that iPhone and part of my chip is found to infringe a patent, right? And I get an injunction, I can't sell my chip anymore. It's not so easy that you just swap in another chip, right? And your iPhone works like it's supposed to. It's that each layer is designed with different companies' technology that works together. It's not like a 1-2 fix. And so that creates different issues for different reasons, right? Like we've talked about, efficient infringement, whereas, maybe the manufacturers like mine will listen more to licensing discussions at the beginning if they're threatened with an injunction, which is true, right? Because now if I sell chips to make iPhones, I have everyone else in the chain coming after me if I'm accused of infringement. But I think it's going to swing too far the other way. Like if I have some guy who's going to come to me with an injunction, he's going to ask me for an insane amount of money, right? If he knows that all of my end customers are going to come after me, like that's not like a good negotiation standpoint for me. Like he could ask for whatever he wants. He's going to disrupt my entire business if I can't sell these chips. So it's not necessarily that I disagree with the Restore Act entirely. I think that injunctions should be a patent remedy that's actually available. I just think it's that the way that technology has evolved, how complex it is, that needs to be considered when we're granting injunctions. And so eBay, right now, the presumption is, you do not get an injunction unless you meet these criteria. The law wants to say you get an injunction unless you meet these criteria. I think that's fine either way, and it is good for the patent owners and the like to have that ability. But there needs to be a real thorough talk and consideration of all the other factors that go into it, especially when you're looking at like high tech, these super complicated devices and what that would mean to actually have an injunction on, technology like a chip in a phone.
I don't have real strong opinions on this one, but that may be because I wasn't practicing before eBay. And so I've only lived in the post-eBay world. I tend to agree. I tend to see this one as being somewhat similar to the Prevail Act in that it does feel like it's just an 180-degree flip, which may be slightly an overreaction. But I also tend to agree that so long as it's a rebuttable presumption, and courts take seriously the considerations that would make granting an injunction unjust and unfair, I think you'll see possibly more power going to those teeny tiny companies that can't defend themselves as easy or can't bring their patent claims as easily, because there is real fear if they get the litigation funding, if they can get into court. There will actually be maybe some real fear on behalf of those big companies that if they keep going, in the end, they're gonna end up with a permanent injunction. So I see value in making permanent injunctions a little more available. But this is another place where I kind of wonder if it's like, did we really need to go from here to here in one fell swoop? But
Right. Well, I see we are now beyond our time, so.
Yes, great. Well, thank you very much. That was a great conversation. I really appreciate it. So.